filing its second affidavit in the sedition case. This is the second affidavit of the centre that has been filed. Remember, the centre has said that sedition should be taken on a case-by-case basis. So the centre has now filed a second affidavit in the case. Well, the centre has made its stand clear. And now, in some breaking news coming in, the centre saying that it is ready to reconsider. That's a reaction coming in as the centre has filed the second affidavit saying it is ready to reconsider sedition. Previously, centre had said that the sedition law should stay, that it should be used in a few cases. There is a possibility of misuse, but it needs to stay. But now, the centre saying it is ready to reconsider and re-examine. That's a big update coming in. Is there a change in the centre stand on sedition? Remember, the centre had previously said that it wants the sedition law to stay because it needs to be invoked in a few cases. Legal editor Harish Nair joins us live. Harish, is this a change in the stance of the centre? Because now the centre is saying that it is ready to reconsider the sedition law.
Yes, very big breaking here. Right now, centre has filed the second affidavit has said that it is ready to reconsider and re-examine the provisions of 124A. Centre has said the Supreme Court must await from centre's reconsideration before proceeding with the hearing of validity of 124A.
Okay, all right, Harish, we'll come back to you. Let's go across to Pranesh as well, who's joining us from the newsroom. Pranesh, the centre there saying that it is ready to reconsider on sedition.
That's the big update on Times Now. We are trying to fix that line with Harish Nair. He's inside the court in Varanasi. The Gyanvapi hearing is set to begin. We'll have Harish Nair back with us shortly. But just to tell you the update that we have, this is a massive Times Now news break. This channel told you first that the centre in affidavit number 1 had told the Supreme Court that this is a well-settled law. The centre in its first affidavit had invoked the Kedarnath Singh versus the state of Bihar judgment and said that this was a 5-judge bench and that this is a well-settled law and that individual cases of misuse are only isolated and the court must take a look case-to-case basis. Now we are being told that the centre has said that we are ready to reconsider and re-examine provisions of 124A. Now we will have to wait before we jump to a conclusion what the centre is trying to say here, because if our viewers can recall, the centre in the past has also said that there is no need to junk the law. However, we are open to reviewing it. Now Harish Nair is telling us that a second affidavit has been filed. The court is hearing a batch of petitions. The first affidavit was filed on Saturday. Times Now got you a copy of that. And in that first affidavit, the centre had made its stand clear. And the stand was, basically there were two takeaways of that affidavit. One, that this is a well-settled law. And like I said, at the cost of repeating myself, the centre invoked the 5-judge bench order and said that this does not have to be reconsidered. The second and perhaps the most important was that the centre said that the petitions that have been filed seeking repeal of sedition have not justified the need to repeal it, and which is why centre in its response said that we will have to scrutinize this on a case-to-case basis. Pratibha.
That's right. In fact, Harish Nair is back with us. Harish, the centre now saying that it will reconsider sedition. Does this mean that the centre has changed its stance? What next? Harish? All right, yes, we'll go back to Harish as he joins us. But Pranesh, as we're talking about it, the centre has now filed the second affidavit in the case saying that it is ready to reconsider and re-examine the sedition law. Remember, the centre has always maintained that the sedition law needs to stay, although in a few cases it is misused. On a case-by-case basis, it needs to stay. In fact, previously as well, in the first affidavit that had been filed by the centre as well, it said that the sedition law must stay. Harish is back with us. Yes, Harish.
Yes, if you look at this para 6 of the affidavit, it says the government of India being fully cognizant of various views being expressed on the subject of sedition, and also having considered the concerns of civil liberties and human rights, while committed to maintain and protect the sovereignty and integrity of this great nation, has decided to re-examine and reconsider the provisions of section 124A of the Indian Penal Code, which can only be done before the competent forum. So very, very big news coming in here that the Modi government has decided to re-examine and reconsider the provision of section 124A. What the government essentially says is that it is perfectly in line with what they have told the court also, that the abuse should end. So they will, in that direction, they're ready to re-examine and reconsider the provisions of 124A. So what it essentially means is that there will be no compromise as far as maintaining and protecting the sovereignty and integrity of the great nation is concerned. So basically the center says that it upholds the Kedarnath Singh judgment, in which in 1962 the Supreme Court had said that when it comes to act which is disturbs the regarding maintaining of law and order, and to act against disorder, and any act to deal with the sovereignty, integrity and unity of the country, and to deal with the violence, acts of violence, 124 should apply. But the center says that it is ready to end the misuse of section 124A sedition. And what is the biggest news is that the center itself has agreed to reconsider and relook a review of the section 124A, the Sedition Act, and is saying that at this juncture the Supreme Court should not intervene and should not pass any orders on a slew of petitions which had challenged the constitutional.
All right, Harish, in fact, stay with us. Thank you for getting us that update, but do stay with us. We have senior lawyer Swapnil Kothari also joining us. Mr. Kothari, what do you make of this statement or the second affidavit of the centre? Does this lay the ground for the scrapping of sedition law?
If I get the information correctly, are you saying that the centre has filed a second affidavit saying that the sedition law should be scrapped or should not be scrapped?
No, the centre has said that they're ready to re-examine the sedition law. All this while it had said that it should stay. Now in the second affidavit it says that it is ready to reconsider and re-examine it.
Well, I think the word re-examine will have dual interpretations. It is open to the idea that it should be scrapped. Secondly, it is open to the idea that it should not be scrapped, or if at all it remains on the statute books, it needs to be tailored down to very specific things, as opposed to the Kedarnath's judgment, which said that there has to be a violent act in 1962. So obviously there has to be a larger bench than the 5-judge bench that sat in Kedarnath. And once the larger bench sits at this time and re-examines this, then the centre is willing to lend a ear to the fact that it should be scrapped. And of course, I think the centre will present its view to the fact that, look, I'm sure that they are not going to say that, okay, let it be scrapped. Otherwise, then there is no debate. If both the sides are saying that the petitioners are saying that it should be scrapped, the centre is saying it should be scrapped, then what's the debate? Then why there has to be even an argument or a contest before the Supreme Court? So obviously they're saying that, okay, let's hear you out. We are not totally opposed to the idea of it being scrapped, but let us re-examine, and they'll present their view, which I think would be in line with the first affidavit that they filed, that it should not be scrapped. But then they are saying that, okay, fair enough, it has to be limited to very specific things. So there'll be some sort of a midway compromise between, rather than a very obstinate stand that they took earlier that it needs no re-examination at all,
okay,
and it should stay the way as it is. So they are willing to bend down a little. It's like reading down. The Supreme Court either lets the statute remain, lets the section remain. It either reads it down or it scraps it.
Okay.
So I think it will be reading it down.
But it's likely to stay. All right, Mr. Swapnil Kothari, thank you for joining us. We have Mr. Majid Memon also on the broadcast with us. Mr. Majid Memon, you had said that the sedition law should be scrapped. Now the centre is saying that it is ready to review it and reconsider sedition. What would you say to that?
See, centre doesn't seem to be firm on its stand. Initially, when the Supreme Court asked them to file an affidavit, they asked for time because they were not very sure as to what stand they have to take qua this sedition law. And later, after having sought time, they filed an affidavit saying that there doesn't seem to be a need to have a relook at it by constitution of a larger bench. Now, they're probably saying that, well, they have no objection if the sedition law is re-examined. You see, all remain 1962. 60 years have rolled by, and in these 60 years, we have had enough experience of the plus and minus points of sedition laws. So therefore, nothing is being lost if a larger bench of Supreme Court re-examines in depth, in detail, the need for society to have this law or to bring some kind of changes in this kind of a law.
Okay, so it's a welcome stand of the centre. Mr. Majid Memon, thank you for joining us. A reminder, though, that your government in Maharashtra has also invoked the sedition law against the Ranas. We're shifting